Hello again, everybody. This is Charles Rather, managing partner at AmLaw Group. How do I expedite my case and get a decision? Believe me, I hear this so many times, and we wish we had a good answer for most people. But unfortunately, in the majority of cases, the answer often is you have to go to court with the government. And ironically, depending what country our client is from, that can really scare them because the thought of suing the government agency that is reviewing your petition and responsible for making a decision on your possible future is really scary for a lot of our clients. In a lot of these countries where our clients come from, you don't go around suing the government, especially that agency that is, in charge of your future, future life here in the United States. So I understand their misgivings and concerns. First thing I want to say is, don't worry. Americans are used to suing and getting sued, and especially the government. So there's nothing personal here. It's only business. And in 15 years of doing this, we've never had a case where there was kind of like a spiteful or vengeful, denial that was issued in the event of litigation. And they just wanted to show put our client back in his or her place or something. I've never seen that, and I've never even heard about it. So that should put aside any concerns you have in that regard. The other problem, or the real problem, I would say, with litigation is the cost. It's not cheap hiring lawyers in America in general, and especially litigators. When you want to try to speed up your case that's being reviewed, it's called a writ of mandamus. Latin term, who knows what it means. But basically, it's basically meaning, hey, the government is dragging its feet here, and it's high time for them to make a decision one way or the other. The court is not going to force the Immigration Service to make a positive decision. The court's role here is just to make USCIS, stop dragging its feet and make a decision one way or the other. And we've been very successful with our mandamuses that we've pursued using our partner attorneys that we work with. I'm trying to think, we've never had a problem with pursuing a mandamus. Now, we can't guarantee every time that when we file a mandamus that the government automatically approves our client's petition and off he goes. No, that's not always the case. Fortunately, in the vast majority of cases, that is true. But many times the government will issue what's called a request for evidence or other informational requests before they make a final decision. And depending on what the client can provide, that affects whether we have a positive outcome or not. But again, the main purpose of a mandamus is to get the government to make a decision. Now, how quickly does this all happen? Well, it really depends on the type of the case. I would say it depends on the type of the case, what court we're filing it in. For example, if we're filing in New York, things tend to be slower there and delayed just because they have so many cases. If you're filing in other states or in other cities in federal court where there's not as much of an intake or inflow, that generally goes faster. I would say on average, it takes maybe a couple weeks to get the case ready and filed. Then the government generally has 2 to 3 months to reply. Sometimes they reply sooner than that. Sometimes they take up all the time that they're given. And sometimes they might even ask for a little bit of extra time. And it's kind of customary in legal circles in the U.S. that if one side is asking for a little extra time, you generally grant that. Now, if they ask for another 2 months to provide a response, we probably wouldn't agree to that. But it often happens where they say, hey, we've been really busy. Can you give us an extra week or 2 weeks to get a response or to speak with USCIS to find out the status? So in those cases, we generally agree to that. So I would say the timeline after filing is we would get a response from USCIS probably within 60 to 90 days. That response could be for anything from, yes, your case is approved, to we will be issuing a request for evidence, within a certain period of time. Or it could be some other alternative that the sides negotiate. In doing this for probably 15 years, none of our mandamus cases ever actually gone to trial. So we've never had a case where we actually had to have a trial and had to give evidence, et cetera, et cetera. Nobody's really interested in spending all that time on a trial. So in probably 99.9% of the time, this all happens in a pre-trial negotiation phase. That the two sides come to an agreement. USCIS might say, will your client be okay if we issue, a decision within the next 30 days, or we issue an RFE within the next 30 days, and then we might stipulate, okay, after they issue the RFE, how much time will they have to review the response and then make a final decision. So we kind of, it's just all done in negotiations. But I would say if you're really in a desperate situation and you need to get your case going, and this applies to immigrant as well as non-immigrant cases, but the vast majority of our cases are related to immigrant visas, many EB-5, in fact, EB-5 cases. Other visa categories, the government is more responsive in terms of responding, providing an answer, a decision, stuff like that. So we rarely do mandamus cases for non-immigrant visas, but this generally comes up in the immigrant situation, and in particular for EB-5. And I should make an extra note too that it's a losing case for the government from the outset if we have to file a mandamus for an 829 in an EB-5 scenario. It's literally written in the law. They have to make a decision within 180 days. And right now it's taking the government 2, 3, 4 years to make a decision on the 829 petitions. I mean, it's ridiculous. It's egregious, right? I mean, the law says 180 days, you have to make a decision. So believe me, this is a slam dunk anytime you go to court with an 829. I'd say it's a slam dunk for the most part for any other type of case, but with 829, there is nothing for them to stand on if it's an 829 situation. And I wish, courts would actually sanction somehow the government so that they change their act and start complying with the law. But unfortunately, it is what it is. So if you're experiencing a delay, whether it's EB-5 or any other kind of petition, please reach out to us and we can discuss how we can help, what the options are, costs, timeframes, and stuff like that, and see what we can do to help you get things moving forward with your case. Hopefully this was helpful for you. If it was, we'd be grateful for any likes that you might make, any comments. Feel free to reach out to us with all our details in the description below, and we look forward to seeing you next time.